Get ready for the dictation in 3, 2, 1, start. It has been held by the Judicial Committee that the words any other sufficient reason must mean a reason sufficient on grounds at least analogous to those specified in the rule. This conclusion was reiterated by the Judicial Committee in Biseswar Pratap versus Parath Nath AIR 1934 and was adopted by our federal court in Hari Shankar Pal versus Anath Nath AIR 1949. The learned counsel appearing in support of this appeal recognizes the aforesaid limitations and submits that his case comes within the ground of mistake or error apparent on the face of the record or some ground analogous thereto. In Fertilizers Industries Limited versus Government of AP AIR 1964 SC 1372, another three-judge bench reiterated that the power of review is not analogous to the appellate power and observed AIR P 1377 para 11. A review is by no means an appeal in disguise whereby an erroneous decision is reheard and corrected, but lies only for patent error. We do not consider that this furnishes a suitable occasion for dealing with this difference exhaustively or in any great detail, but it would suffice for us to say that where, without any elaborate argument, one could point to the error and say, here is a substantial point of law which stares one in the face, and there could be reasonably be no two opinions entertained about it, a clear case of error apparent on the face of the record would be made out. In Aribam Tuleshwar Sharma versus Aribam Pishak Sarma 1979 for SCC 389. This court answered in affirmative the question whether the High Court can review an order passed under Article 226 of the Constitution and proceeded to observe, but there are definitive limits to the exercise of the power of review. The power of review may be exercised on the discovery of new and important matter or evidence which, after the exercise of due diligence, was not within the knowledge of the person seeking the review or could not be produced by him at the time when the order was made. It may be exercised where some mistake or error apparent on the face of the record is found. It may also be exercised on any analogous ground, but it may not be exercised on the ground that the decision was erroneous on merits. That would be the province of a court of appeal. A power of review is not to be confused with appellate powers, which may enable an appellate court to correct all manner of errors committed by the subordinate court. Under Order 47, Rule 1, CPC, a judge may be open to review inter alia if there is a mistake or an error apparent on the face of the record. An error which is not self-evident and has to be detected by a process of reasoning can hardly be said to be an error apparent on the face of the record, justifying the court to exercise its power of review under Order 47, Rule 1, CPC. In exercise of the jurisdiction under Order 47, Rule 1, CPC, it is not permissible for an erroneous decision to be reheard, and corrected. A review petition, it must be remembered, has a limited purpose and cannot be allowed to be an appeal in disguise. In view of the aforesaid facts, reasons, and judicial pronouncements, we see no reason to entertain this review petition as there is no error, much less an error apparent on the face of the record in our order dated 29th July 2020. The review petition is accordingly dismissed. Stop. Thank you.